Okay, so I see everybody is making their way in, and thanks to Professor Dauschmidt for having his class diverted and cut a little short, because I think that this will be a great talk for all of you to hear. We are very lucky to have Professor Veena Duvall of UC Hastings College of the Law, as I understand it, and we're really, really excited to welcome her. She'll also be appearing on a panel this afternoon, but she's going to give a talk now about her most recent research. So please join me in welcoming Veena Duvall.
Thanks so much, Ben, and thank you so much to Abby and to Chelsea and to all the folks who brought me here and invited me and have made this possible. I actually brought my infant, and just to point to how family-friendly this law school is, Abby really helped me find someone. The child is in the room. I'm on maternity leave, so it's really only possible for me to be here as a result of all of the accommodations you've made for me, so I'm grateful. So at the turn of the 19th century, the cotton mill was symbolically equated with new industrial society. As English historian E.P. Thompson famously noted, it was the cotton mill as a novel piece of industrial technology that represented both new forms of production and the social relationships that those new forms of production entailed. Just as observers in the 1800s were intrigued by the novelty of the factory and the technologies associated with it, policymakers, academics, and journalists in this digital moment are consumed by the novelty of app-based technologies and the so-called transformation of service work. In this widespread discussion and analysis, Uber, both the corporate entity and the app, has become the symbolic cotton mill to today's service sector. The cotton mill, however, was not the driving force behind the massive political, social, and economic transformation of the Industrial Revolution. The transformation, rather, was attributable not to the machine, but to capital's restructuring around the machine, to the state's response to that restructuring, and to the collective resistance of the working class amidst these public and private reorderings of work. What we see with the platform-based service economy is not at all analogous to the Industrial Revolution in size or scale. While it accounts for only about 4% of total U.S. work, however, platform-based gig work represents our collective anxieties about digitalization, the so-called transformation of service work, and the political pathologies and economic inequalities associated with widespread labor deregulation. Insomuch as it represents the intensification of labor trends we've been witnessing for the past 40 years, what the digitalization of service work might look like, and also a new moral order, it is worthy of our attention. So given that, I'm going to focus my talk today on sort of bits and pieces of findings from a decade-long project on the taxi and now Uber economy in San Francisco. So my research on taxis began roughly in 2010. It was disrupted, like chauffeur work more broadly, by the thousands of cars enabled by Lyft, Sidecar, and Uber in San Francisco. The research was informed by labor archives, municipal archives, century-old newspaper clippings, personal effects of labor leaders, also 7+ years of an ethnography with taxi driver groups, 3+ years of ethnographic work with Uber drivers groups, a lot of participant observation, hanging out with workers, some engaged participation. I've done, many structured and semi-structured interviews, and also done a 200-person survey of Uber and Lyft drivers in San Francisco. So I am very, very much immersed in this economy. In my historical work, I've shown how since the entree of taxis on the streets of San Francisco in 1909, chauffeur corporations from the taxi cab to now Uber underwent formative business reorganizations to shift liabilities and responsibilities of business onto workers. And counterintuitively, these changes in corporate form over time were met with decreased regulation and a contracted business labor bargain. And I refer to this work as chauffeur work, and I think someone in the earlier panel said, what we call this really it makes a difference in terms of how we think about these things. And so I call this chauffeur work because there's a continuity in the type of work that's being done across the taxi to Uber economy and the people who do it as well. So I'm going to talk about the different epochs four different epochs in San Francisco's chauffeur industry to understand the history of regulation, deregulation, and re-regulation that we're now seeing of the app-based chauffeur economy. So the period from 1909 to 1950, while it was a long time ago, is probably the most compelling and important period to help us understand what's happening today. And then you have this period from roughly 1950 to 1979 that I'll talk about, the post-union period in the taxi industry, 1980 to 2013, and then the current moment from when Uber and Lyft started to become regulated by the state of California. When taxi cabs first appeared on the streets of San Francisco circa 1909, they replaced hackneys, or horse-drawn carriages for hire. They were privately owned, unregulated vehicles operated by a non-unionized workforce, so very similar to what we have today. By 1913, however, taxis were a regulated semi-public utility. By 1918, taxi companies offered a guaranteed wage and a limited workday, so people weren't driving 14 hours a day. And by 1919, 100% of the workforce was unionized. And the first taxi cab model, as you might guess, was actually quite similar. The company model was quite similar to chauffeur companies Uber and Lyft. Based on an unregulated and commission-based business model, these companies produced precarious work with long hours, unpredictable incomes, etc. They provided drivers with the automobiles, they paid a 20% commission, but not a guaranteed wage, and demanded that workers pay for gasoline. But strategic union decisions to fight for both an expansive bargain and robust municipal regulation, so not just the contract. The unions were not just trying to contract with the companies, they were also pushing for robust regulation of the industry, changed this over time. So a decade after these taxi cabs started operating in San Francisco, taxi driving became a site of stable and secure work. To achieve these sort of desirable working conditions, the union embraced a political campaign to influence overall economic policy in San Francisco. They expanded their influence far beyond the wages of workers, ensuring that leisure, dignity, and consumer interests were all part of the bargain. For example, rather than just fighting for better wages within the boundaries of the business model established by the taxi cab companies, they leveraged consumer regulation together with direct action to actually reshape how these companies operated. And so they didn't just secure better wages and good working conditions, but also garnered a great deal of power over the industry, guaranteeing that workers had a voice in regulation. So how did all of this change? Well, I show how during the second epoch that I talk about in the post-war period, after decades of sustained regulation, the union's grip became more slippery. And this was influenced by the legal and legislative decisions made in the 1950s following Taft-Hartley. How many of you have taken labor law? So Taft-Hartley it was the sometimes called the slave labor law. It sort of created demilitarized the possibilities of labor organizing under the National Labor Relations Act. So in addition to these sort of legislative and legal decisions in the 1950s, the political and racial politics of the union in San Francisco in the 1960s and 1970s also contributed to deunionization. So let me first talk about this, the politics of the union. The character of the union and its leadership in the 1950s had changed sort of from more radical to moderate. While the New Deal had legitimized the labor movement and encouraged unionization, Taft-Hartley subdued the union's tactics and in particular undermined direct actions, which were a regular part of industry life in the earlier part of the century. And by the early 1970s, the union's more conservative stance on a variety of social issues, including the Vietnam War and the Civil Rights Movement, led to fracture within its more politically radical rank-and-file members. These are taxi drivers. You can imagine sort of what their politics were in San Francisco in the 70s in relationship to the politics of the union. And the second huge reason that the union power began to unravel was that the cab companies were among the first to take advantage, ironically, of this independent contractor carve-out in federal labor law. So you probably know this, but by the early 1950s, for the purposes of the regime of safety net protections that we have associated with work in this country, there were two groups of workers: employees and independent contractors. And I sort of show in my work how this dichotomy did not exist when for social safety net protections when the New Deal order was passed. So because of all of these protections, it costs businesses up to 1/3 more to have employees than to have independent contractors. And so they were really incentivized to find ways to get out from underneath this law. And so, one of the things that Taft-Hartley did, which was really under-discussed in the legislative history, because I think most work was factory work, so it didn't seem to be as big of a deal as other carve-outs that became part of Taft-Hartley. But one of the things that Taft-Hartley did was actually create an independent contractor carve-out in the law so that independent contractors, people who were deemed legally to be independent contractors, could not unionize. And so what did cab companies do? Well, literally just a few years later, they started to experiment with their business model to see if they could look more like they were hiring or using independent contractors and not workers. So they literally wrote the IRS and they said, if we do this, 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 and this, do we have independent contractors and not workers? And the IRS and then later court said, yes, now you have independent contractors. So the work remained the same, but the business model shifted. So those years set the stage for the following well-recognized era of insecure work. Under a leasing system, so instead of paying drivers a wage or a commission, the companies all of a sudden said, okay, literally overnight, you can rent from us. You can lease from us. So instead of us paying you to work, you pay us to work. So drivers ended up paying for their shift. They leased the vehicle for about 10 hours and then were free to earn or sit idle during that time. The National Labor Relations Board found that these leasing drivers were independent contractors, and the union in San Francisco lost the right to collectively bargain on their behalf. So in these decades that after the chauffeurs union lost the right to collectively bargain, after the union dissolved, labor leaders and worker organizations really arose to unite drivers to stabilize working conditions. But there were really discordant dialogues within the industry amongst the workers about employee status. And I show how this fight about employee status, whether workers wanted to be employees or independent contractors, really created demobilization within the industry amongst workers. And this is relevant to something that I'm going to talk about later on today in the second panel. So if you're here, just hold that thought. So while some workers thought that employee status was intrinsic to labor power because you couldn't have unions without employment status, others felt that they could achieve and maintain economic security with municipal regulations alone. Still, post-union activists were able to achieve a number of key victories for rank-and-file drivers. They maintained the fight for a just wage and safety net benefits. And they did this not through bargaining with the company, because they lost the contract, but through near constant, literally everyday engagement with municipal regulators. So the city and county of San Francisco continued to have decision-making authority over taxi rates and the number of taxi medallions issued, so they controlled supply. And these regulations, of course, were left over from the militant advocacy of the chauffeurs union in the early part of the 20th century, but they leveraged this regulatory framework to create some measure of work stability, income stability in the industry. So for over 30 years, from the late 1970s to 2013, full-time taxi workers had a relatively stable, though low, income because driver advocates could lobby to curtail taxi supply and to control the price of their lease and the taxi fare. So, for example, after 9/11, when tourism dropped dramatically in San Francisco, they were able to go to the Board of Supervisors and say, look, we're not making a living anymore. Can you curtail the number of taxis in the city? Or can you raise the rate so that we're able to balance out our living? So following the decades of sort of relatively stable wages through regulation of the number of taxis, rates, and compensation, San Francisco taxi workers encountered a situation that they really could not have predicted. Economic devastation that happened almost overnight through new chauffeur companies, Uber and Lyft, and the subsequent deregulation that they brought on. So between 2012 and 2013, the next generation of taxi cabs emerged on the streets of San Francisco in the form of private vehicles. These companies, Uber, Lyft, and then Sidecar, enabled drivers to operate outside the state and municipal regulatory frameworks for for-hire vehicles. They enlisted an unrestricted number of commercially unlicensed drivers to download what was a centralized dispatch app, and a technology that actually had just started to exist in the San Francisco taxi industry, so it wasn't a new technology. And under the taxi, so these business models were one step removed from the taxi cab leasing models enacted in the late 1970s. Under the leasing apparatus, the taxi workers were independent contractors who paid to work, but they drove company cars, and they paid for gas, but the companies covered their commercial insurance, wear and tear on the car, they had regulated competition. But these new companies operated outside the context of existing regulations and demanded that workers use their own vehicles, bear all the associated financial and legal risks of the work. And in the first 2 years, workers' rights groups and advocates in the taxi industry engaged in these fervent protests and lobbying of both municipal and state agencies to put an end to what they called bandit tech cabs. By 2013, advocates complained that taxi workers' already low wages had been lowered by 65% because of the competition created by uncapped numbers of Uber and Lyft. This is, I don't have the opportunity in this period of time to put, to give you a real sense of what this economic devastation meant. But for people that are, my friends that I got to know in this industry, people are sleeping in their cars. People have lost their homes. People have, people have killed themselves. The kind of economic devastation that was brought on by the lack of regulation was real. I mean, really real. So California state policymakers ultimately legalized the platform-based chauffeur business models, leaving labor, fares, and number of vehicles on the road completely unregulated. So overnight, all the regulations that taxi workers had fought for and maintained for over a century disappeared. Meanwhile, policymakers heralded the new companies for their consumer convenience and technological innovation. And I should note that California was the first state to legalize these companies because this description I have of them sort of entering San Francisco in 2012, this is the first time that these cars ever existed. These are San Francisco-based companies. They created a whole new regulatory category. These cars could have been regulated by the state under existing regulations for for-hire vehicles for black cars, or they could have been regulated as taxi cabs. Instead, they created this new term, transportation network companies, and adopted extremely lax rules that were then replicated in states across the country and ultimately across the world. Notably, these extremely lax regulations were completely silent on labor issues. They also failed to give workers any leverage to advocate to increase their wages because there is no fare regulation, no vehicle cap regulation, and workers are independent contractors, or at least that's what the companies have maintained. The law is silent about it. In California, as in most every other jurisdiction, there is no vehicle cap, there is no minimum fare regulations, and as I said, and most importantly, I think the TNCs are regulated by an opaque state agency instead of by local regulators. And this is a technique that all of these companies in this economy have adhered to. They've made sure when they are regulated that they are regulated by states and not cities, because it is much harder to change things at a state level than on the city level. So with the legalizations of these TNCs, these Ubers and Lyfts, early 21st century San Francisco chauffeur work rapidly began to resemble early 20th century pre-union San Francisco taxi work. Much like the taxi workers who went on strike in 1919, the TNC drivers had no set income, they paid for their own gasoline, and they drove with no regulatory limit on competition. As an additional regression, they drive their own cars, they bear the costs of wear and tear, which workers do not consider when they're driving. They purchase gas and insurance, they pay for vehicle upkeep, all the while having their on-the-job behaviors incentivized and shaped by algorithms. By 2015, labor unions and alt-labor groups woke up to the needs of these drivers, who were increasingly seen sleeping in their car on the streets of San Francisco after migrating up from Orange County, where the fares were much lower, and still making far less than the minimum wage. So as the technology-enabled contractor business models spread to service industries across the world and across different sectors, the California labor community finally began conversations about how to address this type of growing contingent labor. And in February of 2016, I can tell you down to the month, there was a splinter in the labor community over strategy. So some unions and labor groups thought that the best route was to address the precarious work by fighting for employment status, to say these drivers are employees under the existing employment and labor laws. There's nothing new about this work. We need to push to have them regulated as employees, in large part because we can't push for municipal regulations, because since the state regulates this industry, we're precluded, because of the way the California Constitution is written, from doing anything locally. Others sought a more contentious and expedient route, which was accepting these companies' contention that the workers were independent contractors, and trying to establish non-union worker associations that could fight for something. So in San Francisco, the Teamsters answered the provision of a proposed class action settlement with Uber, which provided for the creation of an Uber-funded worker association of Uber drivers. Now, if these drivers were considered employees by law, an association like this would be a violation of the National Labor Relations Act, because it would be a company union. Unlike the traditional collective bargaining path, which involves organizing drivers, filing for recognition with the NLRB, and then forcing a company to bargain, the Teamsters made the really unusual decision to forego the worker organizing and to attempt to contract on the workers' behalfs directly with the company. The settlement was thrown out, and had it not been thrown out, they would have had to agree to refrain from unionizing drivers, refrain from encouraging them to strike, to refrain from waging legal and political campaigns to change their employment status. And in fact, another union did this in New York City, the independent, ironically named Independent Drivers Guild, which takes we think somewhere between $500,000 to $1 million from Uber each year to give workers portable benefits like telemedicine in exchange for not contesting employment status. So when the settlement was thrown out, because the federal court found that it was unfair, the union Teamsters lost interest in these workers. And what's inhibiting these unions from sort of attempting to organize workers and to really look at things from a regulatory standpoint is fear of antitrust liabilities. Because as you probably know, low-income workers who are considered independent contractors who attempt to use collective action to raise their wages risk being accused of price fixing for better wages. And so unions don't want the financial liabilities associated with this antitrust liability, so they've been very, very reticent to go in to try and organize these workers unless they've contracted in some way directly with the company. So while the Teamsters were in the, let's just work with this independent contractor status camp, those in the other camp, those who wanted to fight for employee status, won a tremendous and unexpected victory at the California Supreme Court in April of 2018, called DYNAMEX v. Superior Court of LA. So before I explain DYNAMEX, let me just give you a little bit of undesirable legal history. So the test in California, and this is considered a worker-friendly test for a really long time, of what constituted an employee was this Borrello multi-factor test. So the common law of agency test on who is an employee relies on control. How much control does the putative employer exert over the putative worker? The more control the employer exerts, the more likely that the worker is an employee. So this was the multi-factor test in California. And it really had a lot of things that made it hard for companies to misclassify their workers. How much, who supplies the equipment, how much financial investment does the worker make, is the work part of the company's regular business, etc. But these things, there was no way in which courts were asked to weigh these factors in any particular way. It was sort of a holistic, multi-pronged test. And so the outcome, as you can imagine, was subjective. Different people were weighing different factors. This is true across jurisdictions where you see the common law test. Different courts and judges weigh different factors and see things in different ways, and so outcomes are sort of not always predictable. So this was the test for a really long time. And in an incredibly important decision, and I want to say 2014, called Alexander v. FedEx, the Ninth Circuit, using this test, found that FedEx home delivery drivers were employees and not independent contractors. And you may or may not know this, but FedEx is sort of the original Uber in terms of using independent contractor workers to slough off labor costs in order to compete with UPS. And I've written a little bit about this. I can direct you to the paper. So this was a huge victory. This case, Alexander v. FedEx, is in all of your employment law books. It's a really big deal in the misclassification sort of plaintiffs bar community. But what do you think FedEx did in response to a decision using this test to say that their drivers were employees? What would you do if you were in-house counsel at FedEx and you really, really didn't want to ever have to deal with a union? Yes, Professor.
Change the relationship a little bit more and relitigate it.
That's right. So that's exactly what they did. They just took the decision and used it as a roadmap to change their business model again. Yeah.
My students do think of that because they're not that cynical yet.
Okay.
We're working on the cynicism.
Yeah. Totally. Well, this is the industry to watch to grow the cynicism. So I've talked to the plaintiffs in this case. I sort of did an interview-based research on the plaintiffs in Alexander, and they are worse off than they were before the litigation, even though they now have employment status, because FedEx is forced, and most of them have left the industry now actually, but FedEx forced them to become small businessmen. So in order to drive for FedEx home delivery now, you have to have 5 routes, which you have to purchase, and you have to have 2 to 3 people working for you so that they really could get out from underneath the Borello test. So because companies have the power under any different versions of this control test to get out from underneath it, and because these tests don't really address the company's power, especially large companies, this is not true for small businesses, but for large companies to sort of reimagine themselves, the plaintiffs' bar had been pushing a new test called the ABC test. And amazingly, sort of in a huge surprise, in 2018, the California Supreme Court embraced this ABC test. And what it does is it creates a presumption of employment status. All workers are employees until the company proves otherwise. And then it goes through this conjunctive test. And yes, you have to be free from control, but critically, you also have to show that the worker is doing work that is outside the usual course of the hiring entity's business. So, if Uber is a software company, then Uber drivers are doing something very different than what Uber does. But if Uber is a transportation company or a transportation network company, as the regulations in California say, then the workers are doing what Uber does, and they cannot get out from underneath the test, or we hope that they could not get out from underneath the test. And so they were very upset by this decision, and they attempted to create an exemption for themselves in that exact same legislative cycle. Jerry Brown, then governor, basically pushed back and said, hold off, we're going to fix this Supreme Court decision in the next legislative cycle under Gavin Newsom. And I don't know how much you guys know about our governor in California, Gavin Newsom, but he's sort of a techno-utopian fantasy person. He wrote this book called Citizenville, all about how the digital economy can change how we govern our people, that we somehow should be governing through social media, instead of through sort of meetings where we're talking with people. So he was, very determined to make some compromise between labor and the gig companies, and he immediately started pushing for these meetings, using his power in all kinds of different ways, keeping labor union leaders who were pushing for employment status off of different committees and commissions, excluding them from meetings. I mean, really using all the political power he had to push for some kind of carve out with the gig companies. But instead of getting a carve out, very, very impressively and surprisingly, we got this law codified by a law that we call AB 5 in California. So this bill codified the test and actually pushed it beyond just the wage orders to California laws regarding unemployment insurance and workers' compensation. So this law, AB 5, actually passed. It was basically, this is all I did as soon as I gave birth, was work on making sure that this law got passed. And it was internationally, and has been internationally heralded. These are just sort of tweets from different parts of the world. I'm getting calls from I'm going to the European European Commission next month to talk to them about it. I've given talks in Korea about it. Regulators are very, very interested in this idea more broadly, I think. I think that less interested in the law. I think that I'm getting a sense that they're more interested in this idea that, they could actually regulate these companies. So the state that created the companies is now stepping in to regulate it. Now, AB 5, the most important part of AB 5 is the enforcement orientation, because these companies have avoided laws for the last 6 years. But what AB 5 does is it empowers city attorneys to sue for injunctive relief. And so you guys have taken remedies, I assume, or some of you. What can you get from injunctive relief if you have an intransigent defendant? I mean, you could even put people in jail for being in civil contempt. of the law. So I have this fantasy of Tony West, like sitting behind the judge in California and like in the holding cell because he won't allow his workers to get a minimum wage. But it hasn't happened yet, in large part because, as you can imagine, the political sort of saga continues behind the scenes between the governor and the tech companies. He has asked city attorneys and the attorney general to hold off on any kind of injunctive relief or any kind of lawsuit even. So 6 weeks into this new year, gig companies like Uber maintain that the law doesn't apply to them and that they need an exemption from it. So on whether or not the law applies to them, Uber's general counsel has maintained that Uber is a platform that does any number of things. So the B prong doesn't apply to them. They actually redid their app to make it look like this. They put their Uber Eats and their Uber X in the same sort of, you click on the app to get the same thing to sort of to prove that they are a software company and not a transportation company. They're also looking into payday loans in the app for drivers, which is like a whole nother issue that I've written about that I'm happy to talk about. But doing all of these things, like really expanding their business model to make it look like they do more than transportation. But just in case a court disagrees with their stance that the B prong does not apply to them, they have put an initiative on the ballot. Do you have a referendum process in Indiana? So this is like one of the most anti-democratic things we have in the state of California, which is basically that you can pass laws by getting them on the ballot after getting a certain number of signatures from the population, and then voters vote on a law that was written not by legislators but by companies or by people, private entities. And so they have this referendum that is going to go on the ballot, and it is pretty awful. The driver's wait time is not paid. They get no employee benefits. Considering that wait time is not paid, we estimate that they are going to make about $5.64 an hour. And probably the worst aspect of all of this is that it would take 7/8 of the California legislature to overturn this law if it passed. And I've never seen, I have a research assistant looking into this, but I've never seen a proposition in my years of watching and voting on propositions in California since 1999 where there was something where it said it would take 7/8 of the California legislature to overturn it. So almost impossible. So if this law passes, it would send a strong signal, I think, to regulators across the country that they need not regulate this gig work, that the companies are going to make it impossible. So while we await regulatory enforcement of AB 5, drivers groups, and in particular grassroots driver-led groups, one of which is called Rideshare Drivers United, are no longer waiting on either unions or on regulators to make things happen. They are taking things into their own hands and drawing up their own ideas for regulation, growing their membership, and attempting to shape their future on a range of issues from wages to what happens to the data that they collect, et cetera. And just last week, after realizing that the California city attorneys were not going to file injunctions against these companies anytime soon, they launched the People's Enforcement of AB 5 campaign, which is really amazing. The drivers themselves created a wage calculator to figure out how much they were owed, which was actually quite complicated. And they helped each other file claims, and they marched to the Labor Commissioner's office last Wednesday and filed 250 claims. And the strategy that they're taking is to overwhelm the Labor Commissioner so that they have to do something on their behalf, which is, although I'm very worried about the referendum, this is the very sort of hopeful aspect of what is going on with regulation in this economy. And I want to leave you with just one thought before I end and take questions, which is that, in the coming years, what will ultimately shape this sector of work in California and beyond California is not the technology that has created it, but the power, I think, of the collective resistance by workers like those who make up Rideshare Drivers United. resistance that I think has the power to force the companies and the state officials to respond to the extreme forms of inequality that many are experiencing, as it did in 1919, before we even had the National Labor Relations Act. So thank you guys so much for listening to my very long story, and I'm happy to take questions.
Have any questions?
Thanks so much for coming, Professor Dubal. I was wondering if you could talk about what to make of how fabulously unprofitable a lot of these big platform companies are, and how you see that as fitting into the labor picture. I mean, on the one hand, it just seems like a blatant and predictable effort to buy off consumers and pit them against workers, but like at some point this Ponzi scheme has to come to an end, right? So how does that interact with the independent contractor issue?
It's a brilliant question and observation about what's going on in this economy. So I have a variety of thoughts about this. One, in my study of the taxi industry nationally, there's some evidence to suggest that the taxi industry has never been successful in its deregulated form. Even when there was a push for deregulation in the 60s and 70s, the companies themselves were not able to, especially in smaller towns, not able to survive. That said, Uber claims that it is now financially successful off of their ride-hailing portion of their application, and that is now subsidizing some of the other sectors. I will say that there is no evidence that we will ever have self-driving cars in the way that the companies pushed us to imagine that we would have self-driving cars, and so. In fact, Lyft just divested from the self-driving car sector altogether. But that is where a ton of their money was going for a really long time. Also, they have a ton of money going into fighting misclassification lawsuits, and not just in the employment context, but in the tort context. So I almost across the board will say no to being an expert witness in cases that are seeking that are not impact litigation, but I said yes to being an expert witness in one case as an ethnographic experience for myself to see how Uber litigated these tort cases. They settled for more money than the plaintiff would have gotten at trial because they wanted the case to go away. They are throwing so much money at these cases, at the accident cases, at the employment cases, at all of the cases that might at some point create some precedent around employment status. So that's where a lot of the money is going. They also have all of these software engineers and social psychologists and social scientists in-house trying to create ways to control the workers without actually controlling them. So they actually employ social scientists to say, like, this is what would make a driver work longer and harder if they get this kind of push button notification at this moment. So there are so many different ways that I can imagine. I mean, one of Uber's founders just purchased, before Jeff Bezos, one of the most expensive homes that was ever sold in Beverly Hills. So I mean, there is money. Like, I think that they could potentially become profitable even by paying their workers a living wage, but they have to rethink how they're doing business. And it seems really simple, but they are espousing. It's not just like a shift in business model. It's a shift in ideology. Like these are like techno-futurists who really think about techno-determinists who really are really committed to a particular vision, a libertarian vision of the world that just does not make sense in this sector. So I think it's going to be more than just the regulations. It's going to be the companies realizing that they fundamentally have to shift how they're thinking about the work that they are putting out into the world. Whether or not that will ever happen or that can actually work, I don't know.
I want to pick a couple of small bones with you.
Sure.
One is you made what to me was in a row two astonishing statements, and I wonder if you meant something slightly different. First, you said that the ballot initiative measure was anti-democratic. Strikes me that it is the most democratic of processes compared to legislation. In conjunction with that, you suggested that the problem with the ballot initiative process was that the proposals were deceptively written, and you didn't say deceptively, but deceptively written by special interests. The implication being that legislation is somehow not drafted by special interest lobbyists. And I wonder if you could, it's not directly related to your talk, but it struck me as problematic.
I'm happy to have a debate with you about the proposition in California and direct democracy at a later date. But just let me quickly say that part of why, and this is a debate that's had in California a lot, but part of the reason why I don't think, in a very sort of succinct way to answer your question, why I think this is so fundamentally anti-democratic is because how it is happening. So to get something on the ballot process, companies are paying workers $10 per signature, going around, and I've done interviews with the people who are getting the signatures, misrepresenting what the ballot initiative says to get those signatures. And so what voters are voting on, or what they think they're voting on, is very different than what they might actually be voting on. And so there's a lot of debate about, and it's not an area that I work on directly. There's a lot of debate about the direct democracy, and I have a huge problem with it. I do think that there's a lot of a lot more misinformation that goes on in that process than that goes into the legislative process, where yes, Uber and Lyft also wrote these laws, but there's some time period where people have to comment on it, to talk about it, to go to lobby for what they want, versus in this process it's sort of a one-time only in and out thing. The only time that anyone can even comment on it is in the ballot and in the conversations they have with the paid people at the grocery store who are making them sign it. And so it concerns me in a very different way than, certainly there are huge problems with the way that special interests have sway in the legislative process, but this is a much more powerful, in my view, problematic way for these special interests to get their way.
Thank you for your talk. I was interested in your comment about prong B of the ABC test and the fact of companies like Uber shifting what their business is about, and how can you nail them down? Because I think our intuitive conception is Uber, that's ride sharing, that's driving. But if they are shifting their business model, how can you nail them down on that prong?
I think it's a really good question. And with these companies that are not profitable but are funded primarily through venture capital, we're not going to be able to. As I sort of mentioned, they're experimenting with banking and payday loans in Venezuela, Brazil, and India. They started Uber Bank in the United States in November of this past year, 2019. So there's a lot of effort to diversify into other places, in large part driven by this sort of regulatory arbitrage or goals for arbitrage. And so I don't know that the ABC test is the final answer to this. It certainly was not what I was advocating prior to DYNAMEX. I personally have long thought that the way to regulate this industry was to go back to the vehicle caps and to fair regulation, and the pushback against that was oh, this is amazing, great consumer convenience. And so I think that there are ways to address that through centralized dispatch. Part of why it was so hard to get a cab in San Francisco for a long time was because when you called Yellow Cab, you were only getting Yellow Cab cars. You were only getting, the 250 cars from the 250 person fleet, versus what taxi workers had been pushing for 2 decades was centralized dispatch. They were pushing for something like Uber, where when you call, you get the full 1,700 1,700 taxi fleet as opposed to just the 200. And so there were ways to sort of address consumer dissatisfaction in the industry while still having vehicle caps, while still having fair regulation. And my prediction would be that in like 20 years, that's what we're going to be again.
Thanks. Maybe I'm not, even though I'm cynical at this point, maybe I'm not cynical enough, but I have often wondered here, especially with when you talk about Uber continuing to resist this, at some point, I think, Assembly Bill 5 casts a pretty broad net. Mm-hmm. And at some point, I would think they would just say, well, okay, we're caught. If we stay in this business model, they are employees. But so are all our competitors. Lyft's drivers are employees. Everybody else is an employee. This is still an incredibly lucrative market. This is still a good app that all kinds of people like to use. My kids love it. Let's just compete and make money. I can see why for a long time they have this competitive advantage over the taxi cab company. But over time, as I understand it, the taxi cabs are now using similar kind of on-demand, you can do it online on your phone to get a cab to arrive or whatever. So they're responding to this. I've been waiting for the first union to come up with their own app that could interface with Uber, and then the question is if Uber can organize the price structure for these people, why can't the union do it and then do it in conjunction with these people? If the one doesn't violate the antitrust law, why would the other one violate the antitrust law? But okay, you're shaking your head at that. But I guess back to the original question is, why are they fighting this so hard? As long as all it's required is that they compete on the same footing with other drive companies.
Listen, you are singing my song, and I have to say, I've been in a lot of these conversations with John Zimmer and with the public policy people, particularly at Lyft. I'm completely sort of out persona non grata. In fact, I think I was called the devil by lawyers at Uber. But they will. Maybe they will in the future, and they're forced. One of the things I said to John was, look, you could totally outcompete Uber here. You already have the good guy image, even though actually workers make more money on the Uber app than they do on the Lyft app. All you have to do is choose employment status, and all of the workers will migrate to your app, and people will use it. And they, again, like I said earlier, they're really ideologically committed to this. Yeah. And so it's not just about how can they make money, and outcompete one another. It's really like an ideological commitment. They will not consider it. And so in their backroom dealings with unions, I've seen what they've offered. And they have offered things that are, not bad, but they will not commit to employment status. They really want the third way, because I think probably they're getting pushed, in addition to the ideology, and I think they're getting pushed probably from their VCs who want a third category of worker, because that opens up a whole new space for service industry investments. If we have a third category of worker on the books, which would be lower than employment status, but something, maybe better than sleeping on the streets and being a migrant worker, they can start investing again in things like HomeJoy and Home Care, all these sort of service apps that that they stopped investing in 2016 because of the rise in these misclassification lawsuits. So they really have been unwilling to even consider it. That's the hard line.
Well, I want to thank everybody for coming to this talk, and I want to particularly thank Professor Dubal for her wonderful remarks. And there is much more of this discussion to come this afternoon at our panel featuring Professor Dauschmidt and Professor Dubal and Leanna Katz. So please come back later this afternoon to engage with more of this discussion. But if you could all please join me in a round of applause for Professor Dubal.